In Washington State, we don't generally use the term custody. We use the term parenting plan. And there are two parts of a parenting plan. One is the residential time, and the other part is the decision making. Residential time is the time that each parent is allowed to exercise parenting with their particular child. Residential time basically means where the child sleeps every night. The other part of the parenting plan is decision making. And that can have to do with where one child goes to school, what kind of activities are involved in, what kind of religion they like to practice. Generally, in a parenting plan in Washington State, decision making is joint. However, if there are any problems with one of the parents, which could include abuse or alcohol or other substances, the courts may allow only one parent to make all major decisions. Some of the things that courts look at when determining the best interest of the child standard is where they're going to live, where they're going to thrive, where they're going to have the best opportunities for school, and just their overall well-being. Some other factors the court will consider in the best interest of the child standard is the history between the parents, the amount of time each parent spends with the child, who takes the children to their appointments, who takes them to their activities, and things such as those. In Washington State, you can change a parenting plan, but the standard is what is considered a substantial change in circumstances. And that can include one parent moving away for a job, one parent ending up having some other issues that precludes them from doing parenting. Another reason to change a parenting plan is if one parent is not following the parenting plan. Now, this can be done, but it can be difficult. In order for that to happen, you have to have significant amount of evidence to show that this change will be in the best interest of the child. A question we get often at Johnson Law Firm is whether I can relocate with a child. And the answer to that question is yes. However, the courts will look at whether or not it's in the best interest of the child, and there are certain things you have to follow. And the main thing is you have to give the other party proper notice and their opportunity to be heard. If you have any questions related to child custody, please give Johnson Law Firm a call. We fight for families and their fresh start.